Hi, I'm Verlan Kwan, a partner at Keystone, a Los Angeles probate firm. In today's video, I'm going to discuss what to do if a party to a lawsuit dies during litigation. Because different sections of the CCP govern what to do when a plaintiff dies during litigation versus when a defendant dies during litigation, an important first step is to determine whether the decedent was a plaintiff or a defendant. If the decedent was a plaintiff, sections 377.30 to 377.35 of the CCP govern. If the decedent was a defendant, sections 377.40 to 377.43 apply. Links to these statutes can be found in our post in the description below. If the decedent was a plaintiff, the next step is to determine whether the claim in question survives death. Examples of claims that survive death includes creditors' claims, elder abuse claims, and actions for recovery of property that belong to the decedent. As long as the cause of action remains and the claim is for or against someone, a claim can be commenced or continued within the statute of limitations. The next step involves determining who has legal standing to litigate the claim. Parties with an ability to litigate claims on behalf of both the deceased plaintiff and the deceased defendant are generally the decedent's personal representative or their successor in interest. A personal representative is the executor or administrator of the decedent's estate. A successor in interest generally is a beneficiary named the decedent's estate plans, an heir of the decedent's estate, or any person with an ownership interest in the subject of the cause of action. When the party with the proper standing to litigate or defend against pending claims has been determined, you can proceed with deciding how to commence or continue the claim. A party bringing a survival claim on behalf of a deceased plaintiff must do so in a timely fashion, either 6 months following the decedent's death or before the statutory time limitations governing the underlying claim would have expired had the plaintiff not died, whichever is later. If the decedent died as a plaintiff in a pending lawsuit, the decedent's personal representative or successor in interest must first file a motion in the court where the case is pending to formally substitute themselves into the action in place of the deceased plaintiff. Once the motion is granted, the personal representative or successor in interest will be permitted to continue the litigation on behalf of the deceased plaintiff. Plaintiffs bringing a claim against a deceased defendant must act quickly as well. Before a plaintiff can commence or continue litigation against a deceased defendant's estate, they must file a creditor's claim in the estate administration proceeding in the probate court. This is to provide the probate court and decedent's personal representative sufficient notice of the pending claim and an opportunity to either accept or reject the claim in full or in part. Plaintiffs with creditors' claims against defendant decedents have 4 months from the date of the letters of administration are first issued to the personal representative or 60 days after the notice of administration of the decedent's estate is given to the creditor, whichever is later. There's another important deadline to keep in mind, the 1-year deadline. Regardless of the other statutes, there is a 1-year statute of limitations from the date of the decedent's death for creditors to bring a claim against the estate. So if within this time frame, a personal representative has not been appointed or an estate proceeding has not commenced, the plaintiff's counsel may have to open probate themselves to prevent their claim from being time-barred. In our experience, when deadlines are missed by inexperienced creditors, it is typically due to this 1-year statute of limitations. The moral is that regardless of whether the decedent had been a plaintiff or a defendant, bringing the survival claim promptly is of utmost importance. Finally, for the last step, you must determine what damages are recoverable on behalf of and against a decedent. For deceased plaintiffs, any damages they incurred prior to their death are recoverable. This includes any penalties or punitive damages the decedent would have been entitled to recover had they still been living. As of recently, damages of the decedent's pain, suffering, or disfigurement are also recoverable so long as the action or proceeding was filed on or after January 1, 2022. For plaintiffs with claims against deceased defendants, all damages except for punitive damages that potentially could have been recovered had the decedent lived are generally recoverable. As you can see, survival claims involve a complex interplay between the probate and the civil courts. This is why we can't stress enough how important it is to work with a probate attorney who has experience in both arenas. That concludes Keystone's video on what to do when a party to a litigation dies. Be sure to subscribe to our channel to be notified when new content has been posted. Thank you for tuning in.